Welcome to Ask a Property Manager, episode number 108. Today we're going to be talking about what to do when a tenant sues you with regards to their security deposit. Can you defend yourself, or do you need to hire an attorney? Stay tuned. So you open your mailbox or you open your front door and someone hands you a packet of paperwork and it says that, hey, you're being sued. You open it up, discover that it's the previous tenant that just moved out of your unit, and they're taking you to court because they're not happy with what you deducted from their security deposit. Today we're going to talk about how to prep yourself for self-representation in court, as well as how to handle yourself in the courtroom. Before we jump in too deep, I do want to take a moment here and mention the fact that I'm not an attorney here in the state of New York, or any other state for that matter, and that you should absolutely be consulting with legal professionals when it comes to making legal decisions regarding your properties. In fact, you may talk to an attorney and discover that after going through all of the information, you don't feel comfortable self-representing yourself, especially in today's courtroom climate. So watch this video, give it some thought, and then make a determination if self-representation is right for you based on your unique circumstances. So we're going to start this off by talking a little bit about the end of the tenancy. When a tenant moves out, depending on your state, you're going to have a certain length of time with which that you need to settle out that tenant's security deposit, mail them a letter, and mail them any remaining security deposit funds that may be available, assuming that the deposit wasn't used in its entirety as part of the closeout of that tenancy. Every state has a little bit different process and procedure, but pretty much universally what's going to wind up happening at the end of a tenancy is there's going to be a settlement of that security deposit, and that needs to be handled usually within a certain amount of time. Take some time to find out what the rules are in your state, because they do vary from place to place. For instance, here in the state of New York, we're supposed to do a pre-move out inspection and notify the tenant of any damages that we intend to charge against their security deposit based on that inspection. The tenant then has the ability to actually cure those damages prior to the move out. So once the tenant moves out, we then have a 14-day time frame that we have in order to get their security deposit disposition letter out the door and return any remaining security deposit to them. Some states will even stipulate that you have to send these documents out certified. You have to return the funds using certified mail. Every state is a little bit different here, is basically what I'm trying to convey. Take the time to find out what the rules are in your state. Now, that security deposit disposition letter, is going to become one of the key things that's reviewed when you actually do wind up in the courtroom. On that letter, you're going to have to specify any of the damages that you're charging for, as well as the amount of those damages. Again, some states will specify that you have to break it out line item by line item. Other states will say you just have to provide the list of repairs and the total amount you're deducting. And again, essentially, that is the reason that the tenant is taking you to court, is because they disagree with whatever information you are using to basically withhold from their security deposit. That's why they're taking you to court. So in preparing for court, you're going to want to pull together a bunch of documents that will help you to kind of build your case. Typically, having a set of move-in and move-out photos and a move-in and move-out inspection sheet, especially if those are signed by the tenant, that's going to help resolve this case very, very quickly. You take a move-in, move-out sheet along with a good set of photos showing what the property looked like at move-in and what the property looked like at move-out. Generally speaking, that combined with a security deposit disposition is going to be sufficient for a judge to be able to take a look at this case and determine whether or not the case has any merit or needs to be heard any further. If you're able to show the condition at the time of move-out versus the time of the condition at the time of move-in, and you can show that there are damages beyond reasonable wear and tear, it should be pretty open and shut for the judge to decide on that case. My recommendation is always bring in any invoices or receipts for any work that was completed, and make sure that all of those documents show that the invoices are actually paid and not outstanding. Don't bring in estimates, bring in paid invoices showing that the work has been completed. Estimates are not going to do you a lot of good in most court situations, because they want to know that the work has actually been done that you're trying to charge the tenant for. In some states, you can only charge the tenant for work that was handled by an outside contractor as well. So if you go in and clean the apartment up, you may not be able to claim your time as part of that security deposit disposition. You really have to know what your state laws are when it comes to stuff like that, which is why I recommend doing that research that we had just talked about. When you are talking about bringing in documents to prove that the work was done, some other things that you can use are canceled checks or bank statements showing that the work was paid for. Essentially what you're doing is you're just creating that paper trail to show that the work has been completed, and you're basically showing that we had to bring the unit back up to standards in order to re-rent it. You may even want to bring some photos showing that the work was completed as well, just so that there's not any question of it, though I don't think I've ever actually had that requested in court. If you're the type of property manager or landlord that likes to complete periodic inspections on your units, you may find that there's information in your periodic inspections that you want to bring with you to court as well. This might be the instance for, a good example would be, say you have a hoarder or someone who is starting to hoard things, and you can kind of show, okay, we were here 6 months ago, there was a little bit of stuff, and now there's more stuff and more stuff. Essentially, you're showing that there's a length of time that this has been an ongoing issue, as well as showing that there is an issue that's ongoing. Having good documentation is going to be critical for something like that. Sometimes you might have notices that you issued to the tenant to correct issues around the property. For instance, with the hoarder, you may have sent them letters telling them, hey, we need you to clean this up because it's starting to become an issue around the property. And then obviously, whenever you send one of those notices, it's a good idea to send photos along with it showing what you want done. If there's no follow-up on that, if the tenant doesn't do the work, doesn't do the cleanup, issuing another notice or taking them to court, that's basically where you're going to find yourself creating your paper trail, so to speak. Essentially, all of those are good to have in court, along with any sort of follow-up photos or inspections, anything along those lines. You're basically working on trying to build out your case in such a way that you can show that you had to get this unit back into rentable condition after that tenant moved out. Last but not least, don't forget to bring a copy of your lease, as well as a copy of the tenant's ledger as of the time that they moved out of the property. Make sure that that ledger shows any unpaid rent, any damages, any late fees, any utilities that went unpaid. Make sure it's a full and complete ledger, because that is something that does tend to get looked at in the courtroom to see just how much the tenant left behind in unpaid rent and damages and things like that nature. As a matter of fact, if somebody's suing you for their security deposit refund, you can countersue them if there's damages above and beyond in most states. So if you have $1,000 security, but there was $2,000 in damages, you can sue for that extra $1,000 above and beyond. Whether or not somebody sues you for their deposit, you can still launch that case. Most people, if they get sued for their security deposit, they're going to then turn around and countersue for something like that in a lot of instances. At any rate, in addition, if you sent any letters at the end of the tenancy indicating how the unit needs to be left in terms of cleanliness at move out, bring that along with you as well. Essentially, you're going to want to bring everything that you can to help you show what documents you provided the tenant indicating that they needed to do some work on the unit to get it back up to spec prior to getting to the point where they were moved out of the unit, either naturally or via eviction or whatever the case may be. When you come to court, bring all of your documents in triplicate so that you can have a copy, the court can have a copy, and the outgoing tenant can have a copy. You're going to kill a few trees here in this process, but it's probably worth it in the long run if you do wind up winning your case. Most courts are not set up for digital document or digital photo display. Don't plan on being able to show people images off of your phone or a tablet or a laptop or something like that. Print the images, print any sort of text message conversations, whatever you have to do, bring in hard copies of that stuff, because that is typically what the court's going to want to see. I think you can pretty much tell based on this video by this point that I have a tendency to really over-prepare for situations such as this, because I want to have that information available to me in the courtroom if I'm asked for it, right when I'm asked for it. In addition, I find that having your documents together tends to make the process run a lot smoother. I'm not going to go so far as to say that a judge is going to side in your favor because you came in and you had all your ducks in a row or whatever, but having your information available to you when the other side may or may not have information available to them, your tenant may or may not have their move in and move out documentation. They may or may not have these photos. If you come in and you have your documentation and the other side doesn't have any documentation, again, it just goes to lean towards your favor when it comes to deciding on one of these cases. So that would be my recommendation. If you're supplying all the information and all the information lines up with what you're seeing in your security deposit disposition letter, the case itself should be pretty straightforward. So if you're taking the time to really prepare your documents and your case before you go to court, it does make a lot of sense, because more often than not, that's going to wind up happening. It's going to wind up falling in your favor, if you will. Now, as for actually appearing on your own behalf in court, as I mentioned earlier, you may or may not want to do that depending on the court climate in your area or whether or not you feel comfortable. You may decide that you want to hire an attorney. One thing I didn't mention, though, is that if you have your property and it's owned inside of a corporation or inside of an LLC, depending on your state, and at least here in the state of New York, you're not going to be able to appear on your own behalf. In those instances where you have a property that is owned by a corporate entity, technically you're not the property owner. The LLC owns the property and you own the LLC. So because of that reason, you don't have direct ownership of the property, and because of that, the courts are going to make you hire an attorney to represent you on your behalf. I've seen that happen time and time again. Occasionally you will get a judge that will allow an LLC to represent themselves, but it seems more and more, at least here in the state of New York, anytime there's a company involved, you have to drag an attorney in on your behalf. Check your state laws to make sure that you don't wind up showing up to court and not even able to defend yourself because you didn't realize you needed an attorney or something like that. When you do show up to court, the process is going to be a little bit different depending on where you're at. But essentially, you're going to get checked in and advised on where you need to sit. And when your case gets called, you're going to wind up at the front of the courtroom in front of the judge. They're going to walk you through the process of how that case winds up being heard, who speaks first, who speaks second, things of that nature. As far as some courtroom tips, again, keep in mind, I'm not an attorney, but I can give you some general advice of be professional. That's the number one thing that I can tell you here. Be the professional that you know yourself to be. I'm not saying you got to go wear a tux or even a suit to court, but maybe don't wear the paint splattered jeans and the t-shirt with the holes in it, you know? During the actual hearing, let the tenant speak. Don't interrupt them. Don't roll your eyes. Don't deep sigh. None of the above. Stand there, smile, listen to what they have to say. You're trying to come across as the professional. You have to come across as the professional here. You're the one who's taking the time to prepare for this court case, and now it's your time to win. The judge will give you time to discuss your side of the case, refute anything that the tenant is saying, display your evidence, etc. They may not require you to display everything. Again, I've given you a ton of stuff that I personally like to have when I go into court to make sure that I'm prepared. You may not have all of these things, and the judge may not even ask for half of this stuff when you get into the courtroom. They may take one look at the disposition letter and a few of the photos and realize that, yes, you are in the right, and they're just going to decide in your favor. But it never hurts to have that extra stuff on the off chance that it does get asked for. You may find the occasional judge that does want to dig a little bit deeper into things, and that's why you spend the time to prepare, so you have that information available to you if you do need it. Some courts will let you know the resolution of the case the same day. Other courts will send you a letter a couple weeks out. But at the end of the day, all I can tell you is best of luck to you as you work your way through the situation. Don't be afraid to call an attorney. Even if you just need a consult, you might be able to get an attorney to give you an hour consult over the phone for a smaller fee than what it would cost to actually appear. And even that might be something that helps set you up for success. Thank you so much for watching. I truly do appreciate it. If you learned something today, do me a favor and share this. Hit that like button, hit that subscribe button, and share it with your friends and family that could benefit from this knowledge as well. Questions or comments, drop them below. We'll talk to you soon.